SJC-10250, Commonwealth versus Mary.
Good morning, Mr. Lossman.
Good morning, Chief Justice Marshall and Justices of the Court. Here this morning on behalf of Stuart Mary. The Commonwealth has conceded, page 19 of its brief filed in this court, that if Mr. Mary was suffering from a debilitating seizure at the time that this crash occurred, he could not, in fact, be guilty of the crime of vehicular homicide. We established through the evidence in this case, through the medical evidence from Dr. Larrick, that he was, in fact, suffering from a seizure which rendered him unable to control the automobile and to avoid the crash. The Commonwealth countered with a rebuttal physician, Dr. Hoke, who testified on direct examination that he could not, in fact, be medically sure, that's his quote, can't be medically sure occurred in this case. I then, on cross-examination, said to him, but you do accept that the concept or the position of the defendant, which is that he was rendered incapacitated by a seizure, is a viable medical theory, and he admitted, yes, it is a viable medical theory. Therefore, the defense presented in this case of an incapacitating medical event, a seizure, was testified to in the defense of Mr. Mary, and it was adopted by the Commonwealth's rebuttal witness as a viable medical theory.
But not the only theory.
I'm sorry?
Not the only theory.
No, not the only theory, but a viable medical theory.
But the jury didn't have to accept that. I mean, I know you're trying to get to the language in Commonwealth versus Webster, but...
And O'Brien.
But the jury didn't have to, I mean, because the experts said it was a viable theory didn't mean that the jury couldn't find, I mean, let me start from the proposition that obviously there are a lot of facts that are in favor of your client. I don't disagree with that whatsoever, but as a sort of logical, theoretical matter, the jury could reject those, couldn't they?
Reject the medical evidence?
Yes.
And reject the testimony of the Commonwealth's witness that it was a viable medical theory that he couldn't rule out?
And find that based on, you know, as the Commonwealth sort of sets out, his foot was on the accelerator, two witnesses saw a sharp turn, et cetera, et cetera, et cetera. Well,
the Dr. Hoke testified that an explanation for the foot being on the accelerator for 11.4 seconds.
I appreciate the fact. I understand that there is another explanation, but I'm just saying the jury doesn't have to, I mean, as a theoretical matter, the jury doesn't have to accept that, do they?
Then the only evidence in front of the jury is that the conditions of the accident, that the car had 98% accelerated depression and 100% throttle.
Well, no, there's more than that. There are two people that saw the car swerve to the left at the very end.
Their testimony, according to the Commonwealth's admission in front of the single justice on July 15th, is that it couldn't be possible.
But the jury doesn't have to believe that. The jury can believe the two people who stood up and said, we saw the car swerve.
It defies, a rational finder of fact cannot believe a fact that defies the laws of physics. The testimony of Sergeant Ryan was that a car going 55 miles an hour that made a turn that was described by the two female witnesses who saw the car coming from the other way, who, by the way, didn't say that they saw Officer Mary at the wheel. They simply described what they believed the behavior of the car was. Sergeant Ryan said a car moving at the speed that she determined it was moving, 55 miles an hour, could not have made that movement physically, forensically, without leaving marks on the street, and there were no marks on the street. In addition to which, the crush damage, which was established by the computer program and testified to by Sergeant Ryan, shows that the cars came together virtually bumper to bumper. The left front half of the cruiser struck the left front half of Mrs. Burns's car as it was parked at the curb, and then after impact, the cruiser rotated its rear end from a 12 o'clock, 6 o'clock orientation.
Is there any reason that the jury couldn't believe that the witnesses simply exaggerated the turn and that the turn wasn't as great as the witnesses said it was?
Any turn at 55 miles an hour, which was the undisputed speed of the cars at the time of the collision, any type of a turn would have left forensic evidence on the street. It is a rational trial.
Wasn't there some qualification by Sergeant Ryan?
I'm sorry?
Wasn't there some qualification of that by Sergeant Ryan?
If it were going 50 miles an hour, it might not leave tire marks on the road if it were just making a normal turn.
But that's not what the testimony was.
That's what she said, isn't it?
The testimony was that it didn't make a normal turn, and I
But the jury could believe that the witnesses were exaggerating the turn.
On my examination of them, I went into great detail to have them describe the turn. And they did so in great detail, and I was very careful to have them explain to the jury the type of movement that they saw the car make. And they were emphatic, and they were consistent about what they felt they saw. That defies the laws of physics. It could not have happened. And the Commonwealth's attorney, Mr. Lynn, in the single justice hearing, admitted that to Justice Cordy. He said it couldn't have occurred the way that the witnesses described it, because they would have left marks on the street, and there were no marks on the
He
street.
said that in the single justice session?
I'm sorry?
He said that?
Yes. I have it. I'm sorry.
Okay, well, if you say he said it.
Page 17 of the transcript from the single justice hearing. The court, at line 21, but I take it your expert testified that there was no sharp movement. Mr. Lynn, it could not have been a sharp turn at the end because that would have left distinctive marks. A rational trier of fact cannot ignore the laws of physics. This car, I'll say it emphatically, this car did not turn at the last moment. This car went in a straight line into the Burns vehicle that was parked at the curb. That was testified to by Mr. Kelsey, who was 15 to...
But even if that's the case, given the, and I understand that there's lots of explanations about why there's no sign of seizure after the fact, that it doesn't necessarily mean there wasn't a seizure. I appreciate that. But it doesn't necessarily mean that there was. So given that, you say the jury couldn't believe that he just drove into the car that was parked there?
Well, he obviously did drive.
No, but I mean that he did so, that the turn isn't a sine qua non of finding him guilty.
You must analyze the evidence in the totality of it. This is a police officer who's on duty. The weather is clear, it's dry, it's cold. It's 9:15 in the morning. He's on patrol. This car goes out of control for 11.4 seconds. It travels over 500 feet at full throttle. It defies a rational explanation that the car could behave this way with a competent, intentional operator at the wheel, particularly under the circumstances of this car.
Wasn't there also evidence that both the brake pedal and the accelerator were operated at the same time?
There was evidence that for the first 3.4 seconds, the brake light was on. The brake light, that's the red light in the rear window. And Sergeant Ryan testified that doesn't necessarily indicate a braking event, but it simply says that the brake light pedal is being activated ever so slightly. That also doesn't...
Well, what does that mean? I don't
It
see
means,
the distinction.
it probably means...
It doesn't slow the vehicle.
I'm sorry?
It does not slow the vehicle.
Correct. That's correct.
But it means some pressure is being applied to the brake.
Some minute forces on it sufficient to light the light in the rear window. We also know that the foot is on the accelerator for those same 3.4 seconds and 8.3 seconds thereafter. So the logical explanation is that somehow his foot is on the accelerator. It's 98% to the floor. The car is getting all the power it can get, and somehow he's caught the edge of the brake pedal sufficiently to light the light in the back, but not to
Well,
create...
that's one explanation. But not the only explanation.
Well, his foot can't be on the accelerator or on the brake at the same time.
How about both feet? Could have one foot on the brake,
Yes.
one on the accelerator.
But it wasn't a braking event. It was only enough pressure on the brake pedal to illuminate the light in the back.
How do you know it wasn't a braking event?
I'm sorry?
How does anybody know it wasn't a braking event?
Because the computer said that. The computer told that to Sergeant Ryan. She said that there was not sufficient pressure on to create a braking event. That was her testimony. The computer will tell you that. It's the PCM, power control module. So what we have is the Commonwealth, at the close of the evidence, doesn't have competent operation. They've conceded that unless they have competent, volitional, intentional operation of the car, they can't prove operation. The other elements of the crime were stipulated, public way and the death of Mrs. Burns. So at the close of the evidence, without any testimony whatsoever, the district attorney gets up, shows a photograph of a broken windshield to the jury and says that this is competent evidence that Mr. Murray was sitting up. And we know that a person sitting up doesn't have a seizure. There's no evidence of that. And the Commonwealth intentionally, with premeditation, stayed away from this issue during the case in chief and during the cross-examination. I asked specifically to Sergeant Ryan, are you able to determine in any way that Mr. Murray was sitting up at the time of the crash? And she said, no, I wasn't.
What about the saliva on the airbag?
There's no evidence whatsoever as to how or when the saliva was put there, or whether even it's his saliva. Let's assume that it is his saliva. There was all kinds of commotion going on in the inside of this cruiser. There were extrication efforts being made by the...
Well, if the jury chose to, could they reach the conclusion, using their own common sense, that in all probability the saliva came because he was sitting upright?
No, I say...
That's not a reasonable inference.
No, it is not, because the saliva and 2 drops of blood or 3 drops of blood and 1 drop of saliva could have been placed there at any point in time.
But also, I mean, just even if they did believe that, without some expert testimony saying that you cannot have a seizure while you're sitting up, it doesn't matter, does it?
That's exactly right.
I mean, it's
That's exactly
irrelevant.
right. We've said that repeatedly in our brief.
So that the problem is the prosecutor arguing, we know no one has a seizure when he's sitting up, or
That's
whatever.
correct. And when I
Well, what precisely did the prosecutor argue? I mean, I have a quote here. This business about a person having a seizure does not sit up. That's mentioned once, right?
Twice,
Is it mentioned twice?
I
Okay.
believe so.
All right. It's mentioned once in connection with the fact that Mr. Kelsey, when he saw the car go by, he did not see anyone sitting up, didn't see a driver.
Correct.
And so I guess the thrust of the prosecutor's argument is that the car proceeded, and since the evidence is that Mr. Murray was sitting up at the time of the crash, obviously someone who has a stroke and is lying down isn't going to sit up. Is that the thrust of one of the arguments here?
Yes, that was the Commonwealth's position, but it's a position that when it was raised, had it been raised during the case in chief, I would have debunked it by doing the mathematics, by showing that the distance that the car traveled in those last 20 to 30 feet, at the speed that it was going, he would have had 0.27 seconds to get in an upright position. It's not physically possible. It's less than the blink of an eye.
But
Mr. Rossman, what about the Commonwealth attempts to make this linkage by saying there was evidence of cuts on the defendant's face? And it's the combination of the blood and the saliva on the airbag together with the cuts on the defendant's face. Presumably, I assume that the assumption is that the defendant was sitting up and his face went into the airbag.
Well, that's one of the things that they would have the jury believe, but there was no testimony about that. And when they had the opportunity to ask either Sergeant Ryan...
There was
or
no
Mr.
testimony about the cuts on the defendant's face?
He was cut on his face. He was bleeding from his mouth and his nose. There was saliva coming out of his mouth when he was laying down. He had cuts on his hands, and he was fighting the extrication in an upright position while they were attempting to put oxygen on him and to also get him out of the car. The saliva and the blood could have been placed on the airbag at any point in time, during the extrication, during the time he was sitting up and they were attempting...
Could you just explain to me, he was fighting the extrication?
Yes, he was combative. He was combative. And the first people tried to put oxygen on him because he turned blue.
Okay.
He fought that. That was the testimony.
He was lying down at the time?
No. If you look at the Commonwealth's brief, they concede that there was testimony from, this is on page 8 of their brief. In a footnote 4, Sergeant Scher's recollection is that they were attempting to put the oxygen on him when he was upright in the driver's seat. And at that point in time, he was fighting the mask and they were chasing him around. He had cuts on his hands. He was bleeding from his nose and his mouth. The blood could have gotten there in any way at any time. And if the Commonwealth were going to argue it, it was incumbent upon them to present expert testimony as to how and when that blood got there. But again...
Am I wrong? Wouldn't you also need expert testimony about the fact that sitting up is indicative of no seizure?
Yes, absolutely. We've said that
To make it
repeatedly.
relevant?
It doesn't matter whether he was sitting up or he was down. The only reason it's in the case is because that's what the Commonwealth argued. You would have to have developed expert testimony from a physician or someone who knew about seizures to take the position, to present the position that the Commonwealth made, which is a person sitting up doesn't have a seizure. A person can have a seizure sitting up, lying down. They can have it while they're up and then end up down. It's of no evidentiary value.
Thank you, Mr. Wilson.
Thank you very much.
Mr. Lynn?
Good morning. May it please the Court, Paul Lynn for the Commonwealth. With me is the trial prosecutor, Assistant District Attorney Nicholas Walsh. The first thing I want to address is this argument about sitting up. It's quoted on page 13 of my brief, and that quote makes it clear that Mr. Walsh was not making the argument that my brother attributes to him. The argument is that Kelsey testifies that he doesn't see a driver. And the prosecutor makes two arguments. That first of all, the first possibility is that Kelsey's simply mistaken, that that there is someone sitting in the driver's seat. But the second possible conclusion, I'm quoting now, is that Kelsey's right. When the car went whizzing past him at 50 miles an hour, Stuart Murray was not sitting up. But remember, that car goes another 20 and 30 feet, and because of the physical evidence that you have to review, we know that Stuart Murray sat up after that point. So he is not saying that a person cannot have a seizure while he's seated upright. He is saying that a person who's having a seizure can't lean over and then pop back up. And that is a reasonable inference.
But then you continue, and members of the jury, a person having a seizure does not sit up. How do we know?
Well, so he doesn't sit back up.
How do we know?
The testimony at trial was
How do we
that
know?
the seizure is that what the defendant would have had is a tonic-clonic seizure. And what that means is that for a certain period of time, the testimony was up to 20 seconds, the body goes rigid. And then immediately after that, the person flops over. That's the clonic phase of the seizure. And thereafter, he's no longer in a rigid position. So it's not, the issue was that he doesn't sit back up. If he's having this seizure, he first goes rigid and then falls over. He doesn't go rigid, fall over, and then sit back up.
There was the evidence that how long does the clonic phase last? If somebody's trying to get an oxygen mask onto you?
There was, I don't think there was any specific testimony about exactly how long the clonic phase, but it would be followed, they said, by a post-ictal phase in which the defendant would still be disabled. He would be simply, they said, flopping around, drooling, combative.
At the time of this incident, I take it was 11 seconds or something thereabouts?
Yes, 11.4 seconds when the accelerator was pressed.
And how long after that when the rescue attempts?
I don't think there was any specific testimony as to seconds, but it was immediate. The eyewitnesses went to the scene. Kelsey and I believe it was Swan, or I can't remember whether it was Swan or Munoz, actually went to the car. But they were eyewitnesses. They were right on the scene, so certainly just a matter of seconds.
What is the physical evidence that makes us know that he sat up after that?
Oh, the physical evidence that we know was the evidence that the prosecutor argued, that there's the blood and the saliva on the airbag. And again,
But we don't know from that that wasn't placed there later on.
true, but it's a reasonable inference from the evidence, and that's what the prosecutor can argue.
Well, if you take the footnote 4, which is that he and Casola lifted the defendant to a sitting position, doesn't that undermine
It might undermine it to the
the
jury.
closing argument? Members of the jury, a person having a seizure does not sit up.
No, it doesn't undermine it at all. It might undermine it to the jury, but the prosecutor is absolutely entitled to make it. The standard is the evidence in the light most favorable to the jury, and the evidence in the light most favorable to the jury was the testimony that they, even despite the combativeness of the defendant, the police officers were able to get the mask on him before he sat up. The testimony was that he was by the time that they got the mask over his face, this is Officer Casola, page 230 of Volume 1, his body was still over the passenger seat, and by the time they got the mask secured, he was half seated upright but still leaned over. So the evidence in the light most favorable to the Commonwealth is the mask is on before the defendant is seated upright again in front of the airbag.
And therefore, the blood and the saliva had to have gotten on there at the time of the accident. So he must have been sitting up in order to do that.
Right. That's the inference. And the prosecutor even acknowledges when he's talking about the blood that yes, blood could have gone anywhere. I am arguing to you that the blood got there when his face hit the airbag, based on the injuries, based on the spots. But he acknowledges explicitly there was blood everywhere. That's not dispositive. And then he moves on to the saliva. He says the saliva came from the mouth. And again, he acknowledges the evidence that the defendant was drooling after he went down. But he argues to the jury they got the mask on him before he sat up, and based on that evidence, you can infer that the saliva came from his mouth when his face hit the airbag, and therefore he was sitting up at the time of the crash.
Mr. Lynn, I have your recitation of the facts, but I haven't read the closing argument. Did the prosecutor suggest some theory as to what had happened? I mean, I have the description of the evidence. Was it,
The Commonwealth's theory was that the defendant was somehow distracted. We were not allowed to argue that there was any specific cause of the distraction because there was no evidence of any specific cause.
Well, so you were properly not allowed. Wouldn't that follow?
I would disagree with that. That it's a reasonable inference that something distracted the defendant. We don't have to explicitly come up with a specific thing, and perhaps the judge was correct to say there wasn't enough evidence to say that there was a specific cause, like his drink. We tried to suggest we were excluded from arguing that. But the distraction.
He had a cup up on the dashboard, or where did you put it?
I believe he put it in a cup holder. I don't think it was up on the dash. And I would point out also regarding, while we're talking about the prosecutor's closing argument, the trial judge in these proceedings explicitly found that the prosecutor did not intentionally forego investigation or questioning of these witnesses. That this was a product of the confusion that was caused by the transfer of this case from the Eastern District and simply the prosecutor's strategy in presenting the case. This was not an intentional attempt to withhold evidence from the defense or to conduct a trial by ambush. So there is a conclusive finding of fact by the trial judge who saw Mr. Walsh's performance that this was not intentional.
Does that make a
misconduct.
difference?
Well, it certainly does regarding whether this case should be dismissed on the grounds of egregious
misconduct.
Oh, I
prosecutorial
see, I see, I'm
misconduct.
sorry.
It certainly, it does affect sufficiency.
Yeah, okay.
So, turning very nicely there to the sufficiency of the evidence, the standard is whether the evidence in the light most favorable to Commonwealth and the inferences drawn therefrom are sufficient for the jury to conclude beyond a reasonable doubt. Here, you have probably as much evidence as you possibly could have without actually having an eyewitness in the car with the defendant that this was not a seizure. You have evidence that the accelerator was pressed. You have evidence that the brake pedal was pushed. You have evidence from 2 eyewitnesses that the car turned. And again, as I quoted Sergeant Ryan, the reconstruction expert, in my brief, she said, yes, if this was a sharp turn, it would have left marks.
Could I just get you to go back regarding the brake pedal?
Yes.
Your brother said that the brake light came on, but the brake pedal was not pushed. That's what I understood him to say.
That's not entirely accurate. What the brake light comes on means that there is some pressure on the brake pedal. It's as I understand the reconstruction expert, the brake light is represented on the records as a 0 or a 1. It's binary. It's either pressed or not pressed. There's no evidence regarding the brake light as to how much pressure was put. And my brother is absolutely correct that there was not substantial braking. There was not the type of braking that would cause the car to slow down.
There was no slowing.
There was no slowing. But you have both of the pedals activated and the accelerator activated to the floor.
But you have an unusual thing, which is that you have the brake pedal, as I understand it. I mean, the depression, the acceleration is going all the time, and the brake pedal, let's say it's a tap, on-off, don't you?
Correct. For 3.4 seconds, just at the beginning, which would be consistent, for example, for preparing for the turn. It's not the best evidence we have. It's just simply evidence that he is operating the pedals at that time. We have 2 eyewitnesses who testify that the car turns, and Sergeant Ryan fully acknowledges that the car could make a turn at 50 miles an hour. It was roughly 52 miles an hour that the accident occurred, without leaving marks. Granted, if it had been as sharp as the witnesses both perceived it to be, it would have left marks. But as this court pointed out when my brother was arguing, the jury was fully entitled to say, okay, obviously it wasn't as sharp as they said, but we can still find a reasonable inference that the car turned. The most reasonable explanation for the car turning is that the defendant consciously turned the wheel.
Mr. Lynn, forgive me. Were there charts for the jury?
Yes, there were exhibits, there were drawings, there were the records themselves.
I haven't looked at those. So can you just tell, the turn was, the witnesses testified that a turn away from the car?
No, it should turn toward the car.
Okay.
As one witness said, it looked like he was trying to avoid something on the road.
What do you say about your brother's reference to the Commonwealth witness who agreed that it was a viable theory that the defendant had a seizure?
There's no question. The medical records are not conclusive. There is no evidence whatsoever in his medical records of a seizure. But all of the expert witnesses, both the Commonwealth's expert witnesses and the defense witnesses, said that's not dispositive. I believe the testimony was that 30 to 50% of seizures would not show any signs based on the tests that were conducted on the defendant. So what the medical evidence is just one brick in the wall of the Commonwealth's evidence. There was no obvious sign of seizure. The defendant has no history of seizures. The defendant had no medical condition that could have led to a seizure, or that couldn't have led, but that indicated that he was susceptible to seizures. So you have the evidence of how the cruiser was operating, both the computer evidence, the diagram evidence, and the testimony of the eyewitnesses, and then you have no medical evidence, as you did in the civil case that my brother cited, where there was no dispute that the defendant suffered a fatal heart attack. In fact, there was someone in the car with him who saw him suffer the fatal heart attack. Here, you have as much evidence as you possibly could have without an eyewitness in the car of conscious operation of the car. The jury was certainly entitled to doubt that evidence and to find the defendant not guilty, but they were equally entitled to draw the reasonable inferences from this evidence and find beyond a reasonable doubt that the defendant was consciously operating his car at the time of the crash.
Thank you, Mr. Lynn.
Thank you.